All right. Good morning, everybody. Welcome to another Climate Connections event. This is Foresight's series of ongoing education. There's so much to know in starting a business, in being an entrepreneur, in growing a business. We want to make sure that we answer some of your questions. Luckily, for all of the fields we touch, there are experts out there, and many of them are kind enough to come here and share a little bit about what they know with you. And that's the idea behind these fireside chats. We're lucky enough to have a fantastic moderator in James Chapea, who will be retaking on that role today, as well as some new special guests talking about incorporating your company in the US. We're starting to sell down there and all the fun things that have to happen. Before I let them get started with the fun, I would be remiss if I didn't tell you about the other great things happening at Foresight. Tomorrow, we have a Climate Connections event on energy. We're going to have 3 industrial partners from the energy space coming in, doing a bit of a reverse pitch. So telling you what it is they need to see in terms of technology development. What do they wish that they had a solution for? Those could be in the short term or medium term, but it's always great to get some connections there to hear it from the horse's mouth, so to speak, in terms of what they need. Next month, in the Fireside Chat series, we will be doing employment law. If you're going to be growing your business and selling internationally, you probably have to hire some people. So as we figure out this piece, we will need to think of some other pieces. Again, we will be surveying you and asking for your feedback on what other topics you do want to have addressed here. So do hang around for the end and fill out that survey and let us know what it is you want to learn more about. Or my esteemed colleague Lee will ask you that right now. The last thing I want to mention is next month, June 14th, 15th in Western Canada, we have an EU event series. So if you want to expand to the European Union, do go to the Foresight website, check out our events page and register for those events and learn more there. Now I'm going to pass it over to Jonathan Troyer, who's going to be introducing our esteemed panelists for today. So
good morning.
Without further ado, Jonathan.
Sorry, you can hear me?
I can.
Perfect. Yeah, sorry, I had some severe technical difficulties getting on here, so I apologize for the late entry here. But thank you. We are incredibly pleased to be here this morning. So I'm a partner, my name is Jonathan Troyer. I'm a partner with the MLT Aikens. We are a full service law firm of more than 270 lawyers based in primarily in Western Canada. We have 6 offices, Winnipeg, Regina, Saskatoon, Calgary, Edmonton, and Vancouver. And I'm one of the lead partners in our emerging growth practice, which is comprised of professionals across multiple legal disciplines who understand the unique challenges facing entrepreneurs and businesses moving from the initial idea to validation to full commercialization, as well as the challenges facing businesses that are looking to scale growth. 2 additional members of that practice are here today, and I'm pleased to introduce them. They will be discussing some of the issues you may face in expanding your business to or investment network to the US. So firstly, Mark Mielke is a member of our corporate finance practice. He has experience advising startups in organizational matters and assisting growth companies with raising capital from various groups, including high net worth individuals, venture capital, private equity, and institutional investors for various purposes, including for commercialization and expansion or scaling of their business. Garnet Matsuba is a member of our tax group, and he focuses on developing tax efficient business structures, including advising on Canadian and international tax planning. As a side note, and Garnet will certainly correct me if I don't quite get this right, but Garnet is a statistician for the Edmonton Oilers as well. And so this will likely be the last time that Mark and I will be speaking with him over the next 2 weeks, given the looming Battle of Alberta.
Garnet, you're on mute. So
now I'll go up a little bit so you can see it, but I made sure I proudly wore my Oilers pin to this session today.
Lee, can we for the Calgarians here, can we just mute him for the rest of this presentation?
Good stuff. So with that, I'll hand it over to Mark and I'll go back on mute.
Thanks, Jonathan. Before we get into the presentation, I just want to deal with a couple of quick things. First off, we're using the web version here. So if you have questions, please put them in the Q&A section. That enables us to actually address them individually to you quickly, or we can actually respond to the entire group. We prefer, it's easier if we're not using the chat, but we'll deal with both. And with that, we don't want to take up any more time, because we really want to turn this over to the guys to talk about a very important topic, because all of us doing startups are going to have to address what does it mean to do business in the US from an investor perspective and an operation perspective. We are not going to deal with the employment portion of that we will deal with at a later date. So there'll be part 2 of this. So let's just hold off on those portions of it. But really important to have you guys here. Thank you very much. This is a very key point for all of us, because you have to think global, and obviously operating in the US is going to be one of the first things. So I'm going to start with Mark. Mark, one of the key things that we have to do when we're operating is, how do we fund our operations? And so part of that is selling our equity. What does it mean when, like, we're a Canadian company, we've been either federally registered or Alberta, are there differences provincially or federally? And get into, well, what does it mean? How do I deal with raising, who can buy my shares? Canada, US? I'll turn it over to you, and you can address the capital raising portion of this.
Awesome. Thanks, James. And, thanks, Stefan and Lee also for inviting us here to talk to everyone today. As Jonathan mentioned, my name is Mark. I'm a securities lawyer here at MLT. As a securities lawyer, I really do 3 things. I do mergers and acquisitions, so I buy and sell companies. I do private market finance. So that's really what we're going to be talking about here today. That's the exempt distributions that I'm going to talk about. And then second or third, I guess, I also do public company work. So I can really help you from your first capital raise, take you all the way to either a sale to a potential new buyer or an IPO. Either way, from start to finish, finance is sort of what I do. So your question, James, is perfect, because in order to really talk about some of the intricacies of raising capital in the United States, first we got to talk about what it is to raise capital in Canada, so that we can talk about the differences and the differences between the 2 jurisdictions. So raising funds in Canada. The starting point when you're raising funds in Canada under securities law is that no person can trade in any security if that trade is a distribution, unless you filed a prospectus with the applicable Securities Commission. So as most people on this call probably know, prospectus is a massive disclosure document. It's typically what you prepare when you're doing your first initial public offering, or when you're doing large scale offerings on stock exchanges. It is a massive document. It will take months to prepare. It requires audited financial statements. So for most startups or early growth companies, what we want to do is avoid having to prepare and file a prospectus. That's too expensive. That takes too much time. So when I'm talking in this presentation about raising capital, I'm going to be talking about raising capital in the exempt market. And what that means is that I have an exemption from filing a prospectus when doing my distribution of securities. So for most startups, early growth companies, all of your first issuances, with maybe a few exemptions for like SPAC companies or capital pool companies, they're all going to be in the exempt market. So any trade in the exempt market requires a prospectus exemption. So the number one sort of takeaway from this question would be, in order to trade securities in Canada, you need a prospectus exemption. And that's where I come in. So as your securities lawyer running your first, second, third cap raise, my job is to ensure that you have a prospectus exemption for each investor that you're issuing shares to. So how do I do that? What's the first step? The first step, for me at least, you all had to build a company and bring it to fruition. But the first step for me is we're going to have to prepare a subscription agreement. And that subscription agreement is the document that governs the issuance of shares from the corporation to the investor and the investment of the money from the investor into your corporation. From a legal perspective, that document is really important because what that document does for me as your securities lawyer is it helps me confirm, based on the representations and warranties in the agreement, that we have that prospectus exemption so that I know that you're doing an exempt distribution in the private market. So when completing a subscription agreement, it's going to take sort of a number of different forms depending on the exemptions that your company is looking to utilize in the market. So just briefly, we're going to talk about perhaps some of those exemptions, because when I'm saying exemption, what I'm really talking about is who can you sell securities to? Because as I started to off the start, in order for this to be an exempt distribution, we can only sell to exempt classes of persons. So one of the most commonly used exemption for startups and early growth companies is called the private issuer exemption. So to qualify for the private issuer exemption, a corporation must be a private issuer, as such term is defined in applicable legislation. So the main benefit why I always direct startups and early growth companies to the private issuer exemption is that under the private issuer exemption, there's no requirement for me or for you, but I'm the person that's going to be doing it, to prepare and file what's called a report of exempt distribution with the Alberta Securities Commission. So for other exemptions that we'll talk about in a moment, there's a requirement to prepare a report that gets filed online with the Securities Commission that contains, it's a disclosure document. So it contains some information about the company. It contains information regarding the use of proceeds, any finder's fees or commissions paid. And importantly, it contains a schedule which includes a line for each investor that invested, their name, address, contact details, amount invested, number of shares received, all of that information. So if you're raising money and you got 40 investors coming in, there's going to be a lot of information in that schedule. And it's a bit of an undertaking to prepare the report on exempt distribution. So to the extent that we can use the private issuer exemption for your first few capital raises, we're going to avoid the requirement for you to get that report prepared. We're going to avoid the filing fees associated with that report that the government of Alberta charges us. And ultimately, we're going to save you some money right off the start. So first distribution, I'm probably going to try and get you under the private issuer exemption from the prospectus requirements. So as I said, what is a private issuer? A private issuer, like most securities law, there's a definition in the applicable national instrument. So to be a private issuer, it's kind of a three-part test. First, you have to have less than 50 shareholders. So for most startups or early stage companies, that one will be easy to make. Second, you must have share transfer restrictions in your articles or constating documents. I can assure you that most companies, 99.9% of companies that are incorporated in Canada or in Alberta, your lawyer is going to put those share transfer restrictions in there right off the start. It would be uncommon for you not to have those. And then third, you can only have distributed shares to the classes of persons listed in the regulation. And there's about 15 different kinds of people listed there. I'm not going to go through them all. The big ones are close friends and family, close business associates, accredited investors, existing security holders, and founders of the corporation. So that's sort of our first bucket of people that we can distribute securities to under that private issuer exemption. So some of those things that I just talked about, close friends and family, accredited investors, they all have definitions too, and I'm going to move on to talk about those now. But so for now, we're going to step out of that private issuer exemption, and we're going to talk about other exemptions available for you to sell securities to. So now that we're out of that private issuer exemption, we're going to have to prepare and file that report on exempt distribution and file that with the Alberta Securities Commission. That report.
Mark, does it matter which province you're in? Because that would only be filing if we're from Alberta. So what if you're BC or Ontario or you're federally registered?
That's a great question. So where you have to file depends on the jurisdiction where the investor is located. So if we're doing a cap raise and you're taking investments from investors in Ontario, Prince Edward Island, and BC, I'm going to have to file in Ontario, Prince Edward Island, and BC. If all of our investors are in Alberta, well, then I just file in Alberta. You also have to file in your home jurisdiction too. So in the event that you were a BC company only raising money in Nova Scotia, you'd still have to file in Nova Scotia and BC.
Okay. One of the things so we covered basically the introduction to, so this is how we get, but what if I now want to also, like, obviously I want to sell shares maybe to US investors or European or somebody else, like, because obviously capital flows. How does that impact? And do they just have to follow in those exact same restrictions so I don't have to report, or how do I deal with that?
Great question. So going into the US is, analogous to raising capital in Canada. It has to be an exempt distribution. Otherwise, you have to file a prospectus. So under Canadian law, there's actually an exemption built in specifically for selling shares to US persons. Awesome. Our legislature thought ahead and thought this through. That exemption says that in order to sell to US persons or people residing in the United States, you have to, quote, materially comply with the local laws of the jurisdiction where you're completing the offering. So what does that mean? I don't know. We called the Alberta Securities Commission and asked them, and their position is that in order to comply with that, you have to get US legal advice. So anytime that you as a Canadian company are raising funds in the US, you're going to have to get a US lawyer to look at that subscription agreement that we talked about off the start and add into that document the US representations and warranties that they need to comply from a US perspective.
Okay. So a quick question has popped up, and it actually is kind of really relevant and timely to this, because obviously when we're selling shares in different jurisdictions, one of the things we want to do is maintain do we want to maintain Canadian controlled private corporation status, and maybe just touch on what CCPC actually is and what it could impact, because I know you guys can actually address that side.
So I'm sorry, James, CCPC is kind of a tax concept, and I know Garnet really wanted to talk about CCPC status, so I don't want to step on his toes.
Okay, let's let him deal with that.
Yeah. One thing that I did want to mention when raising capital in the US is just a bit about process and some of the timelines that you're going to have to be aware of when completing that US cap raise. Okay. So how it generally goes is, you might be working with me, we're completing our cap raise, we're raising across Canada, it's all going really well, and then you found a pocket of investors in the States. Fantastic. That's awesome. We'll definitely be able to handle it. The first step I'm going to do is I'm going to get US legal counsel to review that agreement and layer in those reps. But in the US, there's no private issuer concept like I described previously. So there's always going to be a filing, and that's a filing with the Securities and Exchange Commission. So every distribution you're making in the US is going to have at least one filing. So in order to get that set up, you got to build in yourself a bit of runway, because you make that filing with the US Securities and Exchange Commission through a platform called EDGAR. And it does take 2 to 5 business days to get your EDGAR profile set up. So we just got to make sure that we're managing that timeline correctly. The directors of the corporation are also going to have to complete what's called a bad actor questionnaire. And the bad actor questionnaire is exactly what it sounds like. It's really a questionnaire that the Securities Commission makes all of the directors fill out that sort of answers questions about their trustworthiness, whether they've ever had any felonies or misdemeanor charges with respect to securities law. And then you can get your EDGAR profile set up. So you do kind of need about a week of runway to get that information set up with the Securities and Exchange Commission before you can complete your offering, because the filing is due 15 days after the first offering.
Okay, Mark, this covers obviously common shares, it covers prefs, I'm assuming it covers safes. I'm not sure how it deals with if you're doing a convert or crowdfunding. Like, are these all different, or what's your thoughts on that?
So yes, the short answer is they're all different. The document that governs these prospectus exemptions in Canada is called National Instrument 45106. It's about 100 pages long, and there are a large number of these exemptions. So far, I've only really touched on the main three. For a safe distribution, that is in essence a distribution of securities. In my view, I also called the Alberta Securities Commission and asked them. So we still have to get an exemption when doing a safe. There was recently a new crowdfunding exemption that came in to Alberta. I will be completely honest, I've never done a crowdfunding exemption. I'm not aware of anyone in our office that has. And I think there's two reasons for that. First is that it's a relatively new exemption that the Alberta Securities Commission, sort of just came out with in an effort to make our capital markets more accessible. The other sort of reason why I haven't done one is because the private issuer rules are designed to be flexible and to allow early stage companies to take money on without some of the hoops that you have to jump through with the crowdfunding exemption. It's not quite as straightforward as setting up a crowdfunding page like we'd all hope for. There's a bit more to it, and there's disclosure documents that have to be prepared that, in my view, sort of tilt the economic analysis away from the crowdfunding exemption, because when crowdfunding, the amounts that you're raising are typically a bit smaller than you would in a normal capital raise.
Okay. Okay, so you set the framework, and clearly people need to talk to you before they start doing anything, so they don't get offside. What happens when you get offside and you're not in compliance? Like,
yeah,
where does that lead?
I mean, first thing, James, that happens all the time. So if you're offside, I mean, I'm your lawyer. I can't say it's nothing to worry about, but don't stress. We're here. So often when I'm engaged with companies, sometimes we have to do a little cleanup. And, maybe in the past, business happened, things happen so fast, like maybe we, didn't get US legal advice, or a filing was missed, and that stuff happens. Like, I'm a lawyer, I'm not a law enforcement agent. So my job is to help you clean that up and get you as close as we can to being compliant as we can. And the reason why we want to clean that up is really we're planning for that exit event that I talked about at the beginning. We're planning for your sale, or we're planning for your IPO, because on either of those circumstances, there's going to be lawyers on both sides of the deal team that are going to comb through the documents, and they're going to identify each little instance of non-compliance and ask you to fix it. That's sort of the best case scenario. If there's a whole series of issuances of non-compliance, you might even see perhaps a reduction in the purchase price, or maybe there has to be a holdback in the purchase and sale agreement to sort of account for some of the risks that there are because of non-compliance. But generally, non-compliance happens. Talk to your lawyer. We'll try our best to fix it. I would be remiss if I didn't at least tell you what the penalties are under the Act for non-compliance. So this isn't to scare anyone, but you got to know. So the legislation actually authorizes fines up to $5 million for breaches of securities law, and prison up to 5 years. So you really want to pay attention to securities law. Practically speaking, you're not going to get sent straight to jail. There's going to be a preliminary warning first. In our experience, the most likely sort of first offense is going to be a ban on acting as a director or officer for a period of 5 to 10 years. So while that's a lot better than going to jail, if you're an entrepreneur, you don't want to get banned from being a director or officer. So
the SEC has got about as much sense of humor as CRA does then.
Yeah.
What just quickly before we move over to Garnet some of the tax, what are some of the biggest missteps that you've actually seen?
Yeah, so one sort of common misstep or misconception that I wanted to clear up right from the start is that I've heard people say, like, I need to incorporate in the US in order to get access to US capital. And that's just 100% not true. US funds, US money routinely invest in Canadian companies, whether you're incorporated under the Canada Business Corporations Act, BC Business Corporations Act, you name it, your jurisdiction of incorporation will not be a barrier to their investment. Here in my office, we somewhat routinely see California funds, US funds investing in Canadian companies. They know the law. It's very similar to America. It's just not a barrier whatsoever when in an early growth stage.
Okay. That's actually a really interesting point, because we see and hear that quite a bit, where you have to be. So we're going to turn it over to Garnet, because there's actually real benefit to being a CCPC. And when you're getting your shred in as cash in the bank, that's real leverage to the investors. So to the extent that you are no longer a CCPC and you lose that, the leverage goes away. So I want to see if we can turn this over to Garnet, and if you could talk about a little bit about some of the thoughts here with respect to, like, we always start, we're a Canadian company, been operating here, so this is where I typically start. Just say I'm a software company, because we actually deal with quite a few of those. And let's talk about from an operations perspective to start, and also from that from the ownership side that we've been touching on. What are those implications as far as when we start dipping our toes into the US, and what do we need to do this right and not get offside and run into problems?
Thanks, James. Just before I begin, Mark, I'll just alert you that there are a few questions for you in the chat room and on the Q&A. So I know one of them dealt with the crowdfunding exemption you just referred to, so I'll leave it to you to type answers to those while I'm chatting about the tax issues, if that's okay. So yes, as James referenced a moment ago, often a Canadian business is interested in pursuing opportunities in the US, but we want to test the market with baby steps. So it might start by providing services from here, and maybe even sending a couple of employees down there just to visit potential customers. So under this scenario, the company would not have any permanent presence in the US. Now, under the Canada-US tax treaty, the threshold that's required to subject a foreign company to US federal tax is that of a permanent establishment, or PE. And that's a very important concept as we go forward. So if a Canadian business does not operate through any kind of fixed base in the US, then its activity likely will not be sufficient to be a PE. Now, I do note there are some rules in the Tax Act which deem certain types of activities to be a PE and deem other types of activities not to be a PE, but they're very technical. You could spend an hour on those, so we will not get into those this morning. Now, one important point is that the tax treaty only protects against US federal tax. It does not extend to US state tax. So even if a company from Canada has no US PE, but it does provide services to the US or has employees running around down there, there still may be US state tax obligations because of a concept down there called nexus. And I'll comment on that a bit more in the next segment. I know you're going to deal with employment in a separate session, but I'll just briefly mention that any employees running around the US themselves may face exposure to US income and social security taxes. And I'll discuss that very briefly a bit later. So James, does that cover your question for now about the intro part?
Right. And now let's talk about, because it really ties together this whole concept about what is it to be a CCPC. When we start to raise money, what is it? What is a CCPC? And how do I then become maybe not a CCPC through some of these activities of raising capital?
Sure. Before I get into that question, I'm just going to talk about an intermediary step, and then we'll talk about CCPC, because a Canadian company might decide that it does want to have some US presence, but not necessarily through a separate company. And so the simplest way for it to do that is just operate a US branch. So under that alternative, the Canadian company would use the same legal form, but would not form a separate US company. And that may be more simple to administer. So in that case, the US would impose federal and state tax on US source income, as well as a branch tax that's similar to what dividend withholding tax would have been had the branch been a separate US company, which is 30% technically, but it's usually reduced to 5% under the treaty. So as a resident of Canada, the Canadian company would be taxable here on the US income, but would be able to claim foreign tax credits either in whole or in part to offset the US tax paid. So in Canada, income from this US business activity may not qualify for the small business deduction, as that is limited to income earned from an active business carried on primarily in Canada. And also the US presence may affect eligibility of shares of the Canadian company for the capital gains exemption on a future share sale. So this has to be addressed very carefully. Now, I'll talk a bit more about Nexus, and then we'll get to a discussion on CCPC. So I mentioned in the response to James' first question that states have a concept of nexus, and that establishes the extent to which Canadian businesses may be subject to state tax. And the concept of nexus varies from state to state, because what may not be nexus in one state may be nexus in another state, and vice versa. And I just as an example, licensing of software is commonly considered to be sufficient to create nexus. And states, because they're trying to raise revenue, are increasingly expanding the concept of nexus to encompass not just physical presence, but also economic presence. So it's very important to obtain appropriate professional advice from a US tax lawyer or accountant, and there are some good US tax accountants in Alberta. And the other thing on this point is that there may be some foreign tax credit issues, because what is income for US purposes may not necessarily equate to what is income for Canadian purposes, so there could be mismatching of foreign tax credits. So do we want to talk about potential of opening a separate US company, or do you want me to jump right into your CCPC question, James?
No, so it's actually a really interesting point here. Let me step back. I want to just make sure I get this correct. So there is this concept about whether or not the Canadian company becomes a US taxpayer. Is there a situation, so like, are you going to cover that you set up a separate, and I think we're going to cover this in a little bit, but there's just setting a separate US legal entity to be the US taxpayer separate, and the Canadian company then is not a US, because it sounds like right now that branch idea means that the Canadian company may in fact become a US taxpayer. And does that then stay permanently a US taxpayer, or like, because this is something, how do you do your longer term planning on? How do you do this properly?
Right. I'm happy to clarify that, and then we'll talk about your question about a US subsidiary, and then talk about CCPC's issues, if that's all right. So to respond to your question about the branch, so long as the Canadian company has US presence, and especially a permanent establishment, then it will be a US taxpayer. But just because it's a US taxpayer at the particular time does not mean it's a US taxpayer forever. So if it ceases to have activity in the US, then it no longer would have an obligation to be filing US returns for the Canadian company. But as you mentioned in your comments, the Canadian company might find itself in a position where it's practical and desirable to open a separate US company. So, and often for liability reasons, we recommend that the shares of the US company be owned by a bear holding company set up in Canada, and not necessarily by the Canadian operating company itself. The US company should be what's called a regular Chapter C corporation, named after Chapter C of the Internal Revenue Code. And it should likely not be an LLC or limited liability company, even though LLCs are very commonly used in the US. US people tend to gravitate towards forming LLCs, which is understandable under US tax law, but it doesn't work so well under the Canada-US tax treaty. It gets very cumbersome. When a US subsidiary of a Canadian company earns income from an active business down there, that income qualifies for special Canadian tax treatment called exempt surplus. And what that means is that where you have the US subsidiary company earning active business income down there and decides it wants to repatriate that income to Canada, then although there may be a bit of US withholding tax, the Canadian parent company receiving those earnings would not be taxed here immediately on that income, but only when the Canadian company distributes the earnings to individual shareholders would there be Canadian tax payable by those shareholders. A separate, you may have touched on this already, but a separate US entity may be desirable where the Canadian company attracts some US investors to invest, so the Canadian company is not the sole shareholder of the US company. So in that case, you would have multiple shareholders in the US company. In that case, because the US personal tax system is very different from that in Canada, the US investor may want the business structure to be in the form, say, of a partnership, so that the US investor is not being subjected to double tax in the US on that income. So that, I think, covers issues pertaining to a separate US subsidiary. So let's now turn to your question about CCPC status. And that concerns investment in the Canadian company, because it's very possible, as you, I think, connoted, that the US investor may want to be a shareholder of the whole enterprise, which would encompass the Canadian company and not just, say, the US company we just spoke about a moment ago. So as was raised in a question that I received while Mark was speaking and in your comments, care must be taken in structuring this US investment, as the Canadian company may still want to qualify as a CCPC or Canadian controlled private corporation, because as has been referenced, CCPCs receive special tax treatment up here. And one thing I should clarify before we go on is that even though CCPC connotes that the company has to be controlled by Canadians, that's not correct. If it's 50% Canadian, 50% American, it qualifies as a CPC, because the definition of CCPC is a double negative. It's a company not controlled by non-residents. So if it's 50-50, it is a CCPC, even though the Canadian side isn't, say, 50.1%. So I wanted to make that clear, because the definition is a bit cumbersome in that respect. So talking a bit more about the importance of retaining CCPC status, as many people know, their income is subject to the low tax rate on the first $500,000 of Canadian active business income. In Alberta, that's around 11%. Also, a sale of shares of CCPC is potentially exempt from capital gains tax on the first $900,000 of gain. And as also has been referred to both by, I think, by you and by one of the questions that was posed, there is a difference in entitlement to tax credits for scientific research and experimental development, or called SHRED, because CCPCs are entitled to a 35% refundable tax credit on SHRED expenditures, whereas non-CCPs are much more limited. They're limited to a 15% tax credit, and it's not refundable. So there can be big ramifications there. There's some other things to consider, because certain options to buy shares that are granted to foreign investors may disqualify the corporation from being a CCPC, because in some cases, those shares that are optioned to those foreign investors, they're deemed to have been issued for the purposes of determining whether a corporation is a CCPC. So when you're structuring the shareholders agreement, that often will be necessary to govern the relationship among the shareholders of the company, care must be taken with what rights are being provided to the foreign investors, because you could have a problem if it's not structured properly. And just a final note on this section, again, just dealing with the employee part, it's important to remember that any Canadian employees who are sent to the US, either to work for the Canadian company down there through a branch or second it to a US subsidiary company, if that route is chosen, they themselves may face US personal income tax consequences. And the same goes with social security taxes, such as CPP and EI. And there is a social security agreement between Canada and the US, which to some extent alleviates against double imposition of social security tax, but not always. So and I know employment will be dealt with on another day, but it's important to keep those things in mind as well, because sometimes they take people by surprise. So anyway, do those comments cover that question of yours for now, James?
Yeah, and it clearly is, you know, through some of the questions we've been seeing here, hopefully everybody's gets to see it. It's not straightforward. So you do need to go and ask questions before you start doing some of these things, because you could trip up and find yourself. And now, given that you've got all the different states that come into play and they're operating differently than the federal, I at one point heard that there's something like 1,500 different taxing agencies in the United States. So I know it gets to be somewhat complicated as to who's paying for what and how you do this without losing more hair than what you have.
Exactly.
So what about, you know, when you're looking at, maybe Gary can try and help. What are some of the points that or thoughts you'd have here about what should trigger somebody to ask the right question, just so that when we're saying, well, okay, we're going to go to the US, it's not just simply as hopping on a plane and going down. Are there things that you can do there that are never setting you off, or is it always you just need to make sure you're being careful on this from an individual and a corporate perspective?
Sure. To summarize many of the thoughts that I've referred to, before anyone goes anywhere, you need to work through what states are involved, because as I mentioned, even if the Canadian company has no fixed base in the US and therefore has no PE and should be fine from a US federal tax perspective, the states are not governed by the tax treaty, and even doing things from here with respect to a particular state could trigger some state reporting obligation. And so it's very important anytime you're dealing with this, with a state, to be mindful of nexus issues and items that might need to be dealt with, so that you don't run into unanticipated problems. So
okay, what now? Let's go so now I've decided I've got no choice. I'm a Canadian company, but I'm now going to be, I'm switching to be, I'm going to be a US company. So for whatever reason, and maybe you could touch on some of the reasons why that may actually happen, and where would you go? Why would you do it? And obviously you're in that process, you're going to likely lose CCP status. But thoughts and comments about why you do that switch?
Sure. It has to make economic sense, and that generally occurs when the US people are driving the bus and are requiring for their investment to be maintained that the Canadian company now become a US company. There are a lot of Canadian tax implications associated with that process, because if you have a Canadian company that continues into the US, then for Canadian tax purposes, it's deemed to have sold all its property at fair market value, recognize a gain on any difference between that value and the property's tax cost. And as well, the Canadian company is subject to a 25% departure tax on the fair market value of its retained earnings. So essentially in that case, the Canadian company is taxed as though it had been wound up, with its proceeds then distributed to its shareholders before it continues out of Canada. So this could prove very expensive for the Canadian company. So again, it's presumably a cost benefit analysis that needs to be done as to the benefits of acquiescing to the US segment that may require or request that the Canadian company migrate to the US and become a US company. So you want those benefits, but there is certainly a tax cost associated from the Canadian side that needs to be factored into the decision on doing a migration. So
would you, in that case, because that's going to be likely super expensive, would there be a situation where you actually then, from an operating perspective, you set up a US operation and then you're raising money in the US, not in Canada, and in the US operation, then
right.
Is there a way of actually acquiring the Canadian?
Right. So I think I tried to touch on that a few minutes ago, where let's say you have the Canadian company and you have a separate US company, and you have the US investment in the US company and not upstairs in the Canadian company. And so that probably would be a preferred way to do it. Mark might have some comments on that from a securities law perspective, but certainly that permutation should be considered when structuring the investment by US investors. So as you can tell from our discussion today, there are many different permutations on how these structures can be done. And so there's no one structure that's that fits all for every situation. They generally have to be considered on a case-by-case basis as to what makes sense for the appropriate situation.
Okay. I'm going to ask you the same question I asked Mark. What's the biggest screw-ups you've seen as far as getting this? And like, can you actually get out of some of these things if we have messed it up accidentally? Or is it just going to cost me a lot of money to?
Perhaps if you are able to notice the issue before there are tax filings that get done, there might be an opportunity to adjust. Otherwise, if tax reporting is done to CRA and then it's determined that, for example, this corporation's lost its CCPC status, then perhaps the arrangement which culminated in the loss of CCP status might be examined to see if that's really what was intended, because there is a process called rectification, which requires a court order and the like, which in some circumstances could be used if there's documented evidence that what the parties did was not necessarily what they intended, but the tax courts are much more narrow on applying that remedy because of some cases that went to the Supreme Court of Canada. So it's much more difficult to adjust things after the fact now than before. So if reporting has already been done, then screw-ups become much more difficult to unwind or favorably address. So I think that's all the comments I have on that one for now.
Okay, thank you. I got a question for you. It's been actually in the chat. So the CCPC status, like obviously there's significant benefits that come about this, and you've touched upon, I don't want to go through all the rules because obviously they should come talk to you about this, but you could have US founders, you can have US investors. I know one thing that can throw you offside is there is a look through. So a Canadian investor fund that invests in Canadian, so a quote unquote Canadian fund, there'll be a look through to see who's actually invested in that fund. So you could think that you've got a Canadian investor when in fact it's not. But just quickly touch on, is it as simple as going over 51%, or is there board and management, or what are some of those things that you just need to be cognizant of in this process?
Yeah, well, first, as mentioned, it's not necessarily 51. You can be 50-50 and still be a CCPC, but you're right. There are some provisions in the tax legislation where management does play a part in determining control, and there's some recent case law as well. So you want to be very careful when you're determining your composition of directors and rights in the shareholders agreement to ensure that the company retains CCPC status. And of course, we can help the potential clients in dealing with those kinds of issues because of the downside if they're found not to be a CCPC. And then harkening back to your earlier question, we do have situations where clients think they're CCPCs, report on that basis, obtain their refundable tax credits, etc., and then CRA may come calling. And one of the people submitting questions refer to that type of situation where there's a very negative outcome from that kind of situation. So we know of some situations where there are some skeletons in the closet that we were brought in like after the fact, after things were said and done, where maybe the client changed accountants and the new accountants say, oh, there might be an issue here, and they bring us in and we say, well, you may want to address it through this method or whatever. But sometimes it's the horse is already out of the barn, and so sometimes the parties just decide to cross their fingers and hope that the authorities don't find that issue. But anyway, it can be dicey sometimes.
Okay, a similar topic, say not on the CCP status, but on the PE status, where I'm looking at. So we've got a question about if you're a Canadian company and you want to actually be operating in the US, but you don't want to have a PE, can you use contracting where somebody will be manufacturing in the US instead of yourself doing it? So you subcontract out, or is that just going to throw you offside in any way? Do they look through some of these things?
Likely you can have an independent party doing contract work. There is the concept in the treaty and related materials about dependent and independent parties. And if it's a dependent party, then it's much more likely that entity will be deemed to be a PE of the Canadian company. But usually an independent entity that doesn't have any right to bind the Canadian company contractually and the like, and is truly operating in its own right, that would not form a PE of the Canadian company.
Okay, so clearly then, though, they probably want to have legal counsel just look at what that contract is.
Exactly. Because if the contract's tendered to CRA on an audit and it appears that the so-called independent party is merely a puppet of the Canadian company, that's likely going to be an issue.
Okay. We're getting short on time, but I do want to raise one thing, and it's not about, so we will talk about employment sides later, but this has been really focused on the corporation. But so CEOs and CFOs and so forth, making those trips across borders, are there certain things from an operation perspective that you're better off, say, not signing a contract when you're physically located in the US versus signing? Like, does it matter? What can you do, and what is going to then potentially throw you into being US taxes? And I know this is like, I give it, it's an opinion that you're going to have to say, you don't have all the facts. So
right. I'll offer a general response in that it would be much better from an optics perspective, etc., if contracts involving the Canadian company are signed in Canada rather than in the US, because if you have people actually down in the US signing contracts there, it's much more easy for the tax authorities to put together a number of evidentiary matters like that to determine or to make the case that the Canadian company has now subjected itself to potentially federal US tax and definitely US state tax. So it's very important that people consider in advance what they're going to be doing when they're down in the States and the like.
So I think that one last thing, because I do know some of these US state ones can actually last for a number of years, even if you've actually fixed it. So I think that's probably something that you want to be able to make sure you're doing correctly. I think we're turning to the close to the end. I want to, if there's any last closing thoughts, I know we've got a pop-up here that we're really interested in everybody's thoughts with respect to this. We want to make sure that they can reach out to you and contact you. And I know that there was a question even about, so how do you guys interact with the US? Because obviously you've made mention that you need to have US counsel on for some of these things. How do you actually physically do that?
Well, we have a lot of cross-border files where we're working with various US lawyers and accountants. And so if the client does not already have US advisors, we're happy to recommend a lawyer and or accountant in the US to assist. As I said, There's some good US accountants up here in Alberta, both in Edmonton and Calgary. And so getting good US tax accounting advice does not necessarily mean you have to go to someone in the States, because they're very qualified accountants up in Alberta here who are appropriately licensed in the US and can provide very helpful advice.
Thanks. Mark?
Yeah, and then on the capital raising side of things, I have a firm, they're actually in New York by coincidence, that I use for almost all of our cross-border work. And it's really great because if you're doing a cross-border transaction with me, you might not even really have to engage with these lawyers because I work with them so often. I have their documents, I send them, we have a process that's sort of already worked out, and we'll be able to get them engaged very, very shortly and turn the documents very quickly, just because I've been working with the guy's name is Guy, but I've been working with Guy for years, and it makes the process very smooth because we've been working together so long on these cross-border transactions.
So you have a guy.
I have a guy whose name is Guy. Yeah.
Perfect. Okay. Any closing thoughts, Mark? Turn it back to you now to wind up from your side. Anything you want to leave with everybody?
No, largely thanks to you, James, and to Stephen and Lee for organizing this. And if anyone has any questions about raising capital in Canada, raising capital in the U.S., please don't hesitate to reach out to myself or to Garnet. And like I said, there's or like I alluded to. We do cleanup work all the time. If you got some cleanup work to do, it's nothing to worry about. We're happy to help out in any way we can.
But I take it, given that the parties that are involved, it would be a good idea to probably clean up, not leave it for finding out that you're never going to be working in this area again.
Yeah, you don't want to lose your job.
Stephen, turn it back to you. And Jonathan, thank you so much. Jonathan, appreciate your support and everything you've done. Want to make sure that the contact information is out there so that if anybody online wants to get more information, that they can reach out to you guys.
Yeah, thanks, James. And just to reiterate Mark's comment, I mean, reach out anytime. We do participate in office hours every couple of weeks, but please don't feel limited to office hours. We're happy to have the quote unquote office hour meetings at kind of at any point when it suits the group. So reach out and if there's a particular issue that you want to talk about at those office hour meetings, let us know in advance, and then we can try and coordinate and make sure the right folks are in that meeting with you and are relevant to your discussion.
Thank you, sir.
All right. Thank you very much to all our friends at MLT Aikens. I think Jonathan raises a very good point. There's lots of things we do at Foresight to try and make your life better. There are a lot of things you need to know, a lot of help you need to get, questions you need answered. We try to do that here in our Fireside chats. We're going to try to do that a little bit tomorrow at our Climate Connections event. That is 11 a.m. PS time, noon Mountain, 1 Central, or 2 Eastern. If anybody here is from the Atlantic provinces, that's too confusing. I can't add those sorts of numbers together. The office hours, though, that's a great little sign-up sheet that Tyler sends around. There is obviously support from MLT Aikens and legal advice. There are other specialists there who you can have a little chat with, 10, 15, 20 minutes, get your questions answered quickly. Again, they probably can't, Mike alluded to some cleanup work. They probably can't clean up the work in that period of time, but at least you'll figure out if cleanup work is needed and what it might look like. So do take advantage of that. Do check this out. It is on our YouTube channel, along with a number of other Fireside chats that we have run on a variety of topics. Join us next month, June 14th, for employment law, where we will be here again, sharing nuggets of wisdom, maybe even pearls of wisdom, lots of wisdom either way. Hope you have a great day. I'll talk to you soon.